5 seconds to go. Start. The observations made in para 179 of the judgment in case of Manoj and others versus State of Madhya Pradesh Supra were in the context of the said directions given by the court in the suo motu proceedings and therefore were required to be read in conjunction with the earlier paras 177 and 178 of the said judgment. Stop. Meaning thereby, the prosecution is expected to comply with the draft rule number 4 pertaining to the supply of documents, as and when the said set of draft rules are adopted by the high courts and state governments, giving them a statutory force. Stop. Para. May it be noted that in any case, the draft rule number 4 with regard to the supply of documents under sections 173, 207 and 208 CRPC is part of the chapter 1 of the said draft rules, to be followed during the course of investigation and before the commencement of the trial. Stop. The said draft rule number 4 as and when brought into force after following the due process of law could be pressed into service by the accused only during the course of investigation and during the course of trial, and not at the appellate stage before the High Court or the Supreme Court. Stop. Para. In the aforementioned premises, the attempt made on behalf of the appellant accused and the other accused to delay the hearing of the appeals and the death reference case pending before the High Court, under the guise that they had demanded certain documents from the investigating officer was absolutely reprehensible. Stop. As observed by the High Court in the impugned order, all the papers relied upon by the prosecution were placed by the investigating officer before the trial court and copies were furnished to the accused under section 207 CRPC. Stop. The same have got translated as legal evidence during trial and the case of the accused should have to stand or fall based on that unless additional evidence is sought to be taken. Stop. Para. This court does not express any opinion on the merits of the case, and dismiss the present appeal being devoid of merits. Stop. Para. The registry is directed to circulate a copy of this order to all the high courts, who in turn shall circulate the same to their respective subordinate courts. Stop. Para. Leave granted. Stop. This appeal arises out of an order dated 14 September 2022 in RT number 2 of 2021, by the High Court of Judicature at Madras. Stop. In those proceedings, the High Court had by order dated 27th April 2022 fixed the hearing of the main proceeding, which is a death reference. Stop. Para. The appellant and some others were convicted under section 302 of the IPC along with other provisions and section 120B. Stop. The appellant A1 semicolon A3 semicolon A4 semicolon A5 semicolon A7 semicolon A8 and A9 were sentenced to death. Stop. Consequently, reference was made to the High Court, which was seized of all the proceedings and heard it from time to time. Stop. On 27th April 2022, after ascertaining convenience of all the counsels, the appeals were listed for final hearing on 15th June 2022. Stop. The judgment of Bela Trivedi Judge, has recounted all these facts in detail. Stop. The further proceedings which took place before the High Court, the hearing and the order made on 14 September 2022, declining to direct state to produce documents enlisted in letter written to the public prosecutor on behalf of the appellant on 5th September 2022, is impugned here. Stop.